John Ziegler, Jr. Appearances, counsel.
Judge Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Frank Ziegler. He's next to me at the table. He also stood.
Thank you. We are here for a final pretrial. Is there any resolution in this matter?
Yes, Your Honor, it's my understanding that defendant will plead no contest to count 2 and the people will dismiss count 1. The reason for the no contest plea being potential civil liability.
Mr. Harrison?
I concur in every aspect of that presentation.
All right. Mr. Ziegler, have you heard what the attorneys have said the resolution in this case is?
Yes, sir.
And is that how you wish to resolve it? It's my understanding that you'll be pleading no contest to count number 2. It was a count number 2, correct? Yes,
Yes.
count 2 of
Okay.
assault and battery upon Corbin Hill. The reason for the no contest plea is potential civil liability, meaning that Mr. Hill could turn around and sue you and use that guilty plea against you. So the no contest plea will not allow that to happen as far as a guilty plea to be used against you. In exchange for that, the people will dismiss count number 1 of assault and battery upon John Horn. Now, in order to, well, let me ask you, is that your full understanding of the plea agreement? Now, a no contest plea allows the court to review a document, presumably it'll be a police report, to determine whether or not there's a factual basis to find you guilty of assault and battery. The court can also use that report for sentencing purposes. Do you understand that?
Yes.
And that a no contest plea is essentially accepting responsibility without saying that you're guilty. Do you understand that? Will you please raise your right hand as much as you're able to? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Sir, other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No, sir.
Has anybody threatened you in any way?
No, Your Honor.
And is your own free choice to plea today?
Yes, sir.
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor.
Nor am I, Your Honor.
Mr. Ziegler, do you recall reading and signing the device of rights form that talked about your rights to an attorney, your rights to a trial?
Yes, sir.
Did you understand those rights?
Yes, sir.
Most importantly, do you understand that by entering a no contest plea today, you'll be giving up the right to have a trial and you won't have a trial of any kind? Then to the allegation that on or about June 8th, 2025 in Cedar Creek Township of Wexford County, how do you plead to count number 2, assault or assault and battery upon Corbin Hill?
No contest.
No contest? All right. Mr. Carnes, you have an exhibit for the court to review?
Yes, Your Honor.
I have been provided with what has been marked as proposed people's exhibit number 1, Office of the Sheriff of Wexford County report, case number 83-2501028. Mr. Carnes, you move for its admission.
Yes, Your Honor.
Mr. Harrison?
No objection, Your Honor.
All right, give me just a moment to review that. The 1 provides a factual basis in which to accept the plea to assault and battery in count 2.
Yes,
And
Your Honor. I do. Your Honor.
and that the court rules have been complied with.
Yes, Your Honor.
As does the court, I find the plea is no involuntary and accurate. Sir, I find you guilty of assault and battery on Corbin Hill pursuant to the plea agreement. The assault and battery on John Horn will be dismissed. I also find that the interests of justice are well served in allowing the defendant to enter a no contest plea due to potential civil liability. In particular, the People's Exhibit number 1 makes out that on June 8th, law enforcement was dispatched to the Cedar Creek Township Cemetery for disturbance. Defendant was located at the porta potty yelling. Mr. Hill and another person went over to the porta john where the defendant was threatening to kill somebody. The defendant then grabbed Mr. Hill by the shoulders and threw him down to the ground. While the victim attempted to get up, Mr. Ziegler then placed him in a headlock. As such, I find that the facts are made out for an assault and battery. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Is there any victim impact?
Your Honor, the victim did state he doesn't know who's going to come after me. And I think the victim, I apologize if it's a little bit, but I think the victim is a minor, so that is disturbing. He did say there was no injury.
Mr. Harrison?
Well, I'm sure it was a scary day for everybody involved, including Frank. As the court is aware now, having read the police report, this was a series of misunderstandings. Mr. Horn was interested in speaking with Mr. Zygo because he thought Mr. Zygo had trespassed. In effect, they cornered him in the back of the cemetery. At one point, Mr. Horn produced a weapon. And Mr. Hill and another young gentleman, Mr. Johnson, were standing nearby, and Frank reacted badly and instigated physical contact with Corbin. I think we can play the what if, what for game if you want to, because if Mr. Horn had simply left Frank alone and filed a police report, okay, he doesn't have to do that. He can in effect make a citizen's arrest under those circumstances. I'm aware of that, so is Frank. If the two young men had not been at some level curious as to what was happening in the back of the cemetery, or had not been in his presence, we can't undo any of that. I'm just saying this was not Mr. Zygo seeking out a victim and imposing himself on somebody else. What Frank wants is what everybody wants, is to be left alone. We've talked about it, he and I have, about how would be a more appropriate way to accomplish that same goal, to be left alone. And I think we've developed something of an understanding between the two of us as to how that was going to happen. I don't think he's a good candidate for supervision. I think his record demonstrates that. I also don't think any more jail time is necessary. He's been in jail since the date of the incident. And although he's been seen by CMH in the jail, I know for a fact he does much better on his own. Again, I'm not trying to impose blame or pass it off onto anybody else, or to even suggest that Frank's actions were warranted or frankly even understandable that day. What I'm saying is it was the perfect storm of circumstances and he exploded. I think he's in a better place now, both in his outlook toward other members of society, as well as just in general, how to stay left alone. That's what he really seeks to do, and I think he has a plan together to accomplish that. I would recommend, or I guess encourage the court to impose a straight jail sentence that consists of the time he's already served. Whatever appropriate cost fees.
Thank you. Mr. Ziegler, you have the right to address the court prior to sentencing. Is there anything you would like me to know?
No, sir. On the iron.
All right. Well, Mr. Ziegler has pled to a 93-day misdemeanor and has already 81 days under his belt. I'm sorry, Mr. Carnes, I forgot to ask you, any allocution?
Your Honor, I recognize that fact too. No. No, I haven't.
All right. So the sentence today will be 81 days jail with 81 days credit. I'm not going to place the defendant on probation. I don't see, where the next few days are going to get me anything, or society anything. So it will be a jail sentence of 81 days with 81 days credit. I'm only going to order what I have to for fines and costs of a $75 crime victims' rights fee and $50 state minimum fee. Mr. Harrison, do you have any issue with waiving the attorney fee?
None whatsoever.
All right, so fines, costs, and attorney fee will be waived. Mr. Ziegler, you will be released at some point today. I do have to inform you, even though it's time served, I did sentence you to a period of incarceration. So if you decided that you wanted to appeal that decision and could not afford an attorney to assist you, you have 14 days in which to file for an appointment of an attorney to assist you. And also any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. So your fines and costs today were $125. And then you still owe the court $294 from a prior incident. So I'll need you to get, once you're able to, get set up on a payment plan, all right?
I'm gonna try to take care of this as soon as possible.
Okay, thank you. Good luck to you, sir.
All right, let's talk about that. This Wexford County case wrapped up with a plea and sentencing that showed how judges weigh the facts, the risks, and the practical realities of jail time. Indant Frank Ziegler Jr. faced 2 counts of assault and battery. As part of the plea deal, he pled no contest to 1 count involving Corbin Hill, while the other count involving John Horn was dismissed. The no contest plea wasn't just strategy, it was protection against potential civil liability. The court explained that a guilty plea could be used against him in a lawsuit, while no contest avoids that problem. Ziegler confirmed he understood, waived his trial rights, and let the court rely on the police report to establish the factual basis. That report painted an odd scene. Law enforcement was called to a cemetery after Ziegler was found yelling inside a porta potty. Hill and another person approached, and things escalated. Ziegler grabbed Hill by the shoulders, threw him down, and later put him in a headlock. The victim later expressed fear, noting he was a minor and worried about retaliation. The defense framed it differently. They said Ziegler hadn't gone looking for trouble. He felt cornered, reacted badly, and exploded in what his attorney called a perfect storm of circumstances. They stressed he wasn't a good candidate for probation, that he does better on his own, and that with 81 days already served, more jail time wouldn't serve anyone. The judge agreed. Sentencing was quick. 81 days in jail with credit for all 81 served. No probation, no supervision, just time served. The only costs imposed were the statutory minimum fees, with attorney fees waived. The judge even acknowledged there wasn't much more to gain by keeping him longer, adding a reminder about setting up a payment plan for older court costs still on the books. The courtroom tone was pragmatic. The prosecution stuck to the facts. The defense admitted his behavior was wrong, but pushed for perspective. And the judge closed it out with a sentence that balanced accountability with the reality that Ziegler had already done his time. Time to break this one down. Frank Ziegler left court free that day, with time served, no probation, and a reminder that blowing up in a cemetery porta potty isn't the kind of memory anyone wants to repeat. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.